I never thought my first day as the new facilities director at Mercy General Hospital would end with me standing in a conference room full of lawyers. But here I was, watching the HOA president's face turn the color of a fire hydrant as she realized just how catastrophically she had messed up. My name is Daniel Dawson, and I had been working at Mercy General Hospital in Scottsdale, Arizona for exactly 6 hours when the water stopped flowing. 6 hours. I hadn't even finished filling out my new hire paperwork when my assistant burst into my office, her eyes wide with panic. "Daniel, we have a serious problem," Sarah Martinez said, practically vibrating with anxiety. "The water pressure just dropped to nothing in the surgical wing." I stood up immediately, my coffee forgotten. "What do you mean nothing?" "I mean the taps are dry, completely dry. The surgical team had to postpone 2 procedures because they can't scrub in properly." My stomach dropped. A hospital without water was not just an inconvenience. It was a catastrophe waiting to happen. I grabbed my radio and followed Sarah out of my office, already pulling up the facility schematics on my tablet as we jogged toward the mechanical room. "Has anyone checked the main feed?" I asked. "Maintenance is looking at it now, but Daniel, there's something you need to know about our water supply." We turned a corner, nearly colliding with a nurse pushing a medication cart. I mumbled an apology and kept moving. "What about it?" "The hospital's main water line runs through the property of the Sunset Ridge Homeowners Association. It's been that way since the hospital was built in 1987. The land used to all be owned by the same developer, and when they split it up, they established an easement for our water line." I felt a cold dread settle in my chest. "Please tell me we have that easement properly documented." "We do. It's ironclad. But the HOA has been difficult lately. Really difficult." We reached the mechanical room where 3 of our maintenance workers were huddled around a set of pressure gauges, all reading 0. Tom Chen, our lead plumber, looked up when we entered, his expression grim. "Someone shut off the main valve," he said without preamble. "And it's not on our property. It's approximately 200 feet that way." He pointed west, toward the residential development that bordered our campus. "Could it be a water main break?" I asked, already knowing the answer but hoping I was wrong. Tom shook his head. "I called the city. No reported breaks in this area. Water pressure is normal everywhere else in the neighborhood. Someone physically closed the valve on our feed line." I pulled out my phone and dialed the number Sarah had scribbled on a sticky note for me. It rang 4 times before a woman answered with a tone that could have frozen lava. "Sunset Ridge HOA. This is Deborah speaking." "Hi, Deborah. This is Daniel Dawson, the new facilities director at Mercy General Hospital. We seem to be experiencing a water outage, and our maintenance team believes the valve on our main feed has been closed. The line runs through your HOA's property, and I was hoping you could help us figure out what's going on." There was a pause that lasted just a beat too long. "Oh yes, that was intentional." I blinked, certain I had misheard. "I'm sorry, what?" "The board voted yesterday to shut off that valve. Your hospital has been using our water without proper compensation for decades. We're well within our rights to control access to infrastructure on our property." My grip tightened on the phone. "Madam, we have a legal easement for that water line. It's been in place since before your HOA even existed. You can't just shut off water to a hospital." "Actually, Mr. Dawson, we can and we did. If Mercy General wants continued water access, you'll need to negotiate a new agreement with our board. I suggest you bring your checkbook to our meeting next Tuesday evening." "Next Tuesday? That's 6 days from now. We need water restored immediately. We have patients in critical care, surgical procedures scheduled, and basic sanitation requirements." Deborah's voice took on a saccharine quality that made my skin crawl. "Then I suppose you should have been more considerate about maintaining positive relations with your neighbors. The board finds your hospital's current arrangement to be unacceptable. Good day, Mr. Dawson." She hung up. I stood there for a moment, staring at my phone in disbelief. Sarah was watching me with growing alarm. "She shut off our water on purpose?" she asked. Apparently the board thinks they can extort us for easement rights we've held for nearly 40 years. I turned to Tom. "How long can we run on reserves?" "We have backup tanks that can supply the critical care units and surgical suites for maybe 12 hours. but we'll have to shut down everything else. No showers, limited toilet use, the cafeteria will have to close. And that's assuming nothing goes wrong. I was already dialing again, this time calling my boss, the hospital's chief operating officer, Marcus Webb. He answered on the first ring. Daniel, I heard we have a water situation. It's worse than a situation, Marcus. The Sunset Ridge HOA deliberately shut off our main feed. They're trying to force us into some kind of new agreement. Marcus swore, which was unusual for him. Are you absolutely certain it was deliberate? I just spoke to their president, Deborah something. She admitted it outright and told me to come to their next meeting with a checkbook. That's insane. They can't do that. We have an easement. I told her that. She doesn't seem to care. Okay, listen to me carefully. Get me everything you can find on that easement, every document, every filing, everything. I'm calling our legal team right now. In the meantime, we need to start implementing water conservation protocols and notify the city health department about the situation. Already on it. I spent the next hour coordinating the emergency response. We activated the hospital's crisis management protocols, redirecting non-emergency patients to other facilities, postponing elective procedures, and implementing severe water restrictions throughout the campus. The backup tanks were engaged, providing minimal water to the most critical areas. By noon, our legal team had assembled in the executive conference room. I sat across from 3 attorneys, including our chief counsel, Patricia Morrison, a woman in her early 50s with steel gray hair and an expression that could cut glass. This is the easement agreement, Patricia said, sliding a stack of documents across the table. Recorded in 1987 when the original developer, Southwestern Properties Inc., split the parcel. The hospital received perpetual access rights to the water main running through what's now the HOA's common area. It's absolutely binding on all subsequent property owners. So they have no legal standing to shut us off, I asked. None whatsoever. This is not just a contract violation. This is potentially criminal interference with a medical facility. I've already drafted an emergency motion for a temporary restraining order and preliminary injunction. We'll file it within the hour. Marcus leaned forward. How fast can we get before a judge? I've been in contact with Judge Harrison's chambers. Given the emergency nature and public safety implications, he's agreed to hear us at 4 o'clock this afternoon. I glanced at my watch. It was 12:30. What do you need from me? A detailed declaration describing the impact this is having on hospital operations. Be specific about any patients or procedures affected. We need to demonstrate immediate and irreparable harm. I spent the next 2 hours documenting everything. 3 surgical procedures postponed, including 1 cardiac catheterization that was time-sensitive. 2 patients in the ICU who needed to be transferred to other facilities because we couldn't guarantee water for dialysis. The closure of our emergency department for anything except the most critical cases. The potential for complete facility shutdown within 12 hours if water wasn't restored. At 3:30, I climbed into Patricia's car along with Marcus and another attorney named James Rodriguez. We drove to the Maricopa County Superior Court building in downtown Phoenix, a 20-minute drive that felt like an eternity. Judge Richard Harrison's courtroom was smaller than I expected, wood-paneled and austere. We took our seats at the plaintiff's table just as a bailiff announced the judge's entrance. Harrison was a man in his mid-60s, bald except for a fringe of white hair, with eyes that missed nothing. This is an emergency hearing in the matter of Mercy General Hospital versus Sunset Ridge Homeowners Association, the judge said. I've reviewed the moving papers. Is counsel for the defendant present? A woman stood up from the back of the courtroom. Your Honor, Linda Martinez representing the HOA. I only received notice of this hearing an hour ago. We request a continuance to properly prepare our response. Judge Harrison looked at her over his reading glasses. Ms. Martinez, the plaintiff is a hospital that currently has no water. How long of a continuance did you have in mind? At least a week? Your Honor, we need time to review the allegations and the underlying easement agreement. 1 week without water for a functioning hospital? The judge's tone made it clear what he thought of that suggestion. I don't think so. This court is prepared to hear argument now on the plaintiff's motion for emergency relief. You'll have an opportunity to present a defense. Linda Martinez looked flustered. but sat down, immediately conferring with a man who had been sitting next to her. I recognized him as probably someone from the HOA board. Patricia stood and approached the podium. Your Honor, this is a straightforward case. Mercy General Hospital has a recorded easement dating back to 1987, providing perpetual access to a water main running through the defendant's property. Yesterday, without warning or legal justification, the defendant's board of directors voted to shut off a valve controlling that water line. They did so deliberately and with full knowledge that they were cutting off water to a hospital serving the Scottsdale community. She placed a stack of documents on the clerk's desk. We've submitted declarations from the hospital's facilities director, Mr. Daniel Dawson, detailing the immediate harm this is causing. Surgeries are being postponed. Critical care patients are being transferred. The emergency department has been effectively closed. If water is not restored within hours, the entire hospital will be forced to shut down. Judge Harrison picked up one of the documents. What possible justification does the HOA claim for this action? According to their president, they believe the hospital should be paying them for the easement access, despite the clear legal right established nearly 40 years ago. This is nothing more than extortion, Your Honor. The judge turned his attention to Linda Martinez. Counsel, I'm listening. Martinez stood, smoothing her skirt nervously. Your Honor, the HOA's position is that the easement agreement is outdated and doesn't reflect current property values or maintenance costs. The water line runs through HOA common area, and the association bears the cost of maintaining that property. They're simply trying to negotiate a fair arrangement. By shutting off water to a hospital, Judge Harrison's voice was dangerously quiet. Without notice, without attempting any negotiation beforehand. The HOA has tried to contact the hospital numerous times over the past year about renegotiating the agreement. Patricia was on her feet immediately. That's completely false, Your Honor. The hospital has no record of any such contact. And even if there had been communications, that doesn't give the HOA the right to unilaterally terminate an easement. Judge Harrison held up a hand. Does the defendant dispute the validity of the easement agreement itself? Martinez hesitated. We believe there are grounds to challenge it, Your Honor, but we haven't had time to fully research the issue. In other words, no, you don't actually dispute it. You just don't like the terms. The judge closed the folder in front of him. Here's what's going to happen. I am granting the plaintiff's motion for a temporary restraining order. The defendant is hereby ordered to immediately restore water service to Mercy General Hospital. And I mean immediately, as in before you leave this courthouse, you will be on the phone with whoever needs to be contacted to turn that valve back on. Your Honor, we object, Martinez began. Your objection is noted and overruled. Furthermore, I am scheduling a preliminary injunction hearing for next Friday at 9 in the morning. At that hearing, the defendant will have the opportunity to present any legal argument as to why they should be allowed to interfere with the plaintiff's easement rights. I warn you now, you had better have substantial legal authority supporting your position, because from where I'm sitting, this looks like one of the most clear-cut cases I've seen in years. The judge looked directly at the man sitting next to Martinez. Are you a board member? The man stood awkwardly. Yes, Your Honor, I'm Craig Stevens, the HOA treasurer. Mr. Stevens, do you understand the order I just issued? Yes, Your Honor. Then I suggest you get on the phone right now and make sure that water is flowing again within the hour. If I hear that there has been any delay or resistance to this order, I will hold you and your entire board in contempt. Am I making myself clear? Yes, Your Honor. Good. This hearing is adjourned. The gavel came down with a sharp crack. We stood as the judge exited. I felt a wave of relief wash over me, but it was tempered by the realization that this was far from over. Craig Stevens was already on his phone, his face red as he spoke in urgent, hushed tones. Linda Martinez looked shell-shocked. Patricia gathered her documents. That went about as well as we could have hoped. Judge Harrison doesn't suffer fools, and he clearly sees this for what it is. How long until we can expect water back? I asked. Based on the judge's order and his threat of contempt, I'd say within an hour, maybe less. They're not going to risk defying a direct court order. She was right. By the time we made it back to the hospital at 5:15, Tom Chen was waiting for us in the lobby with a huge grin on his face. "We've got water," he announced. "Full pressure restored about 20 minutes ago." I could have hugged him. Instead, I just clasped his shoulder. "Thank God. Start bringing everything back online, but let's do it systematically. I want to check every system before we declare full operational status." Marcus headed upstairs to brief the hospital administration and start the process of rescheduling postponed procedures. I spent the rest of the evening with the maintenance team, verifying that every faucet, every toilet, every piece of water-dependent equipment was functioning properly. It was past 8 o'clock when I finally made it back to my office. Sarah had left a note on my desk saying she'd already sent out an email update to all staff about the water restoration. I collapsed into my chair, suddenly aware of how exhausted I was. My phone rang. I didn't recognize the number, but answered anyway. "Daniel Dawson?" "Mr. Dawson, this is Deborah Chamberlain from the Sunset Ridge HOA. I believe we got off on the wrong foot earlier today." I sat up straighter. "So this was the infamous Deborah. Mrs. Chamberlain, I'm not sure what foot you think we got off on, but from my perspective, your organization shut off water to a hospital full of patients. I'd say we got off on a criminal foot." Her voice took on that same saccharine quality from the morning. "Now, there's no need for hostility. The board simply wants what's fair. That water line runs through our property, and we deserve compensation." "You have no legal basis for compensation. We have an easement. A judge just told you that this afternoon." "Judges can be wrong, Mr. Dawson, and even if the easement is valid, it doesn't prevent us from exercising our rights as property owners. We're prepared to be reasonable, but we expect the hospital to be reasonable as well." I pinched the bridge of my nose, trying to hold on to my temper. "Mrs. Chamberlain, let me be very clear. The hospital is not going to be extorted. We have a legal right to that water line. If your HOA interferes with it again, we will pursue every legal remedy available to us. That includes criminal charges if appropriate." "Is that a threat?" "It's a statement of fact. Have a good evening." I hung up before she could respond. Something about her tone bothered me beyond the obvious. There was a quality to it that suggested she wasn't taking the judge's order seriously, like she thought this was all just negotiation theater. I forwarded the call information to Patricia with a note about the conversation. Then I finally headed home to my apartment in Tempe, a 30-minute drive that gave me too much time to think. The next morning, I arrived at the hospital at 7 to find Marcus waiting outside my office. His expression told me something was wrong before he even opened his mouth. "We need to talk," he said. "My office." I followed him upstairs to the executive suite. Inside his office, Patricia was already there, along with the hospital's CEO, Dr. Helen Richardson, a petite woman in her early 60s who radiated competence. "Daniel, thank you for coming up," Dr. Richardson said. "We've had a development overnight." Patricia slid a document across the table. It was a lawsuit filed late yesterday evening. I scanned the caption, "Sunset Ridge Homeowners Association versus Mercy General Hospital." "They're suing us?" I asked incredulously. "After what happened yesterday." "It gets better," Patricia said grimly. "They're alleging that our easement is invalid due to improper recording procedures in 1987. They're also claiming we've been trespassing on their property and demanding damages for 38 years of unauthorized water use." I stared at the document. "This is insane. The judge just ordered them to restore our water." "That order stands," Patricia confirmed. "But they're trying to create a parallel legal proceeding to challenge the underlying easement. It's a delay tactic, and not a particularly good one. But it's going to require us to defend against these allegations." "Doctor." Richardson leaned back in her chair. "Patricia, what's your honest assessment? Do they have any chance of succeeding with this?" "Realistically, no. The easement was properly recorded, and we have clear chain of title documentation. But litigation takes time and money. My guess is they're hoping to force us into a settlement by making this as expensive and painful as possible." "That's not going to happen, Doctor," Richardson said firmly. "We're not paying them a dime for rights we already have. I want you to file a motion to dismiss this lawsuit immediately, and I want you to explore every possible legal claim we have against the HOA. What they did yesterday put patients at risk. There have to be consequences." I'm already working on it, Patricia said. We have several options. We can counterclaim for damages from yesterday's water shutoff. We can report them to state regulators for interfering with a medical facility. And depending on how far we want to push it, we could potentially pursue criminal referrals. Do all of it, Dr. Richardson said. I want these people to understand that you don't mess with a hospital. Over the next week, the legal battle intensified. Patricia filed a motion to dismiss the HOA's lawsuit and a comprehensive counterclaim seeking damages for the water shutoff. We documented over $200,000 in losses from postponed procedures, patient transfers, and emergency operational costs. The preliminary injunction hearing was scheduled for Friday morning, and I was scheduled to testify. Patricia prepared me thoroughly, walking me through the types of questions I might face and making sure I understood how to present the facts clearly without getting emotional. Friday morning arrived with typical Arizona sunshine, the temperature already climbing toward 90 degrees by 9 when we assembled in Judge Harrison's courtroom. This time, the HOA had brought reinforcements. In addition to Linda Martinez, there were 2 more attorneys, both from a larger firm downtown. The HOA board was also present in force: Deborah Chamberlain, Craig Stevens, and 3 other board members I didn't recognize. Deborah was exactly what I had pictured from our phone conversation. She was in her late 50s, with short blonde hair styled in a severe bob, wearing a designer pantsuit that probably cost more than my monthly rent. She had the kind of face that looked like it had forgotten how to smile sometime around 2003. Judge Harrison entered and we all rose. Please be seated. This is the preliminary injunction hearing in Mercy General Hospital versus Sunset Ridge Homeowners Association. I've reviewed the supplemental briefing submitted by both parties. Before we begin testimony, I want to address the separate lawsuit filed by the HOA counsel. For the HOA, you filed a complaint challenging the validity of the hospital's easement. Do you seriously expect this court to believe that an easement properly recorded for 38 years is suddenly invalid? One of the new attorneys, a man in his 40s with slicked-back hair, stood up. Your Honor, Ronald Prescott representing the HOA. We believe there are legitimate questions about whether the original easement complied with Arizona law regarding perpetual property interests. We've retained an expert in property law who has identified several potential defects in the recording process. Judge Harrison looked unimpressed. You understand that the burden of proof for invalidating a recorded easement is extraordinarily high? We do, Your Honor, and we believe we can meet that burden. We'll see. For now, let's proceed with the preliminary injunction hearing. Counsel for the plaintiff, call your first witness. Patricia stood. The hospital calls Daniel Dawson. I made my way to the witness stand, raised my right hand, and swore to tell the truth. Patricia led me through my background, establishing my credentials as the facilities director, and then walked me through the events of that first day. Mr. Dawson, can you describe what happened when you discovered the water had been shut off? I was informed by my assistant around 11 in the morning that water pressure had dropped to 0 in the surgical wing. When we investigated, we found that the main valve controlling our water feed had been closed. The valve is located on property controlled by the Sunset Ridge HOA. What did you do? I called the HOA office and spoke with Mrs. Chamberlain. She confirmed that the board had voted to shut off the valve and told me that if we wanted water restored, we needed to come to their next board meeting with a checkbook. There was a murmur in the courtroom. Deborah's face remained impassive, but I saw Craig Stevens shift uncomfortably in his seat. How did the water shutoff impact hospital operations? I went through it all in detail. The postponed surgeries, including the cardiac catheterization for a 72-year-old man that had to be delayed by 3 days, the ICU patients who had to be transferred, the closure of the emergency department, the cost of implementing emergency protocols and operating on backup water supplies. In your professional opinion, Mr. Dawson, what would have happened if water had not been restored when it was? We would have been forced to completely shut down the hospital within 12 hours. Every patient would have had to be transferred to other facilities. The impact on public health and safety would have been catastrophic. When Patricia finished, Ronald Prescott stood for cross-examination. He was good. I had to give him that. He tried to suggest that the hospital had been negligent in not having better backup systems, that we should have been more proactive about negotiating with the HOA, that the whole situation could have been avoided if we had just been willing to talk. I kept my cool and stuck to the facts. Mr. Prescott, we have a legal easement. We didn't need to negotiate anything. Your client shut off water to a hospital without warning and without legal justification. That's not a failure on our part. That's a deliberate act of interference by the HOA. After I stepped down, Patricia called Tom Chen, who testified about the technical aspects of the water system and confirmed that the valve had been deliberately closed. Then she called Dr. Susan Park, the chief of surgery, who described the medical impact of postponing procedures. When the plaintiff rested, Prescott called Deborah Chamberlain to the stand. She took the oath with her chin held high, projecting an air of absolute confidence that she was in the right. Mrs. Chamberlain, can you explain why the HOA board voted to close the water valve? Prescott asked. Certainly. The HOA has been concerned for years about the hospital's use of infrastructure on our property without compensation. That water line runs through our common area, land that our homeowners pay to maintain. We've reached out multiple times to discuss a fair agreement, but the hospital has been completely unresponsive. Have you documented these attempts to contact the hospital? We have emails and letters dating back over a year. Patricia was on her feet. Objection, Your Honor. There's been no foundation laid for these alleged communications, and none were produced in discovery. Judge Harrison nodded. Sustained. Mrs. Chamberlain, do you have these communications with you? Deborah looked at Prescott, who shuffled through his papers. Your Honor, we can provide them. They're in our files. Then you should have brought them today. Continue. But I'm not giving this testimony much weight without documentation. Prescott pressed on. Mrs. Chamberlain, did the board consider the impact on the hospital when making the decision to close the valve? Of course we did. We're not monsters. We assumed the hospital would have backup systems for such a critical facility. We thought this would prompt them to come to the negotiating table. And were you aware that the hospital claims to have an easement? We were aware of the alleged easement, yes, but our attorney at the time advised us that there were questions about its validity. We believed we were within our rights to control access to our own property. Patricia's cross-examination was surgical. Mrs. Chamberlain, you said you assumed the hospital would have backup systems. Did you actually verify that before shutting off the water? Well, no, but it seemed reasonable. So you gambled with patient safety based on an assumption. You didn't call the hospital to ask about their backup systems? We didn't think we needed to. You didn't think you needed to verify that you wouldn't be putting patients at risk before shutting off water to a hospital? Patricia's tone was sharp. Did you consult with any medical professionals before making this decision? No. Did you consult with the city health department? No. Did you notify the hospital before taking this action? No, we didn't want to give them a chance to try to stop us. I saw Judge Harrison's eyebrows rise at that answer. Patricia continued. Mrs. Chamberlain, you mentioned alleged communications with the hospital. Do you know the name of anyone at the hospital you supposedly contacted? Deborah hesitated. I don't recall specifically. It was our property manager who handled most of that. And is your property manager here today? No. So we have no one who can actually confirm these communications took place? They're in our files, Deborah insisted, her composure starting to crack. Then produce them. Mrs. Chamberlain, the truth is your board never contacted the hospital before shutting off the water, did you? We tried to. That's not what I asked. You never actually made contact with anyone at the hospital administration about renegotiating the easement before you shut off that valve, true or false? Deborah's face flushed. We may not have made direct contact, but we attempted to. Attempted to doesn't cut it when you're interfering with the hospital's operations. No further questions. The hearing continued with more technical testimony, but the damage was done. When both sides rested, Judge Harrison didn't even take a recess to deliberate. Sir, I've heard enough, he said. The plaintiff has clearly established entitlement to a preliminary injunction. The easement is valid and properly recorded. The defendant's actions in shutting off the water were not only legally unjustified, but reckless and dangerous. The preliminary injunction is granted. The defendant is enjoined from interfering with the hospital's water access in any way. Violation of this injunction will result in contempt sanctions, including potential incarceration of responsible board members. He looked directly at Deborah. Mrs. Chamberlain, I want to be absolutely clear. If your HOA touches that valve again, if you in any way interfere with the hospital's water supply, I will not hesitate to put you and your fellow board members in jail. Do you understand? Yes, Your Honor, Deborah said quietly, her earlier confidence completely gone. Furthermore, I'm referring this matter to the Arizona Attorney General's office for investigation into potential violations of laws governing medical facilities. Shutting off water to a hospital is not just a civil matter. It may well be criminal. That got everyone's attention. Prescott stood quickly. Your Honor, we would object to any criminal referral. The board was acting in good faith based on advice of counsel. Then your counsel gave you terrible advice. The referral stands. This hearing is adjourned. We walked out of the courthouse into the bright Arizona sunshine. Patricia was practically glowing. That was even better than I hoped. Harrison absolutely crucified them. What happens now? I asked. The preliminary injunction stays in place throughout the litigation. We continue with our counterclaim for damages, and we wait to see if the Attorney General's office decides to pursue criminal charges. Marcus clapped me on the shoulder. You did great in there, Daniel. Let's get back to the hospital. We have a lot of work to do. That turned out to be an understatement. Over the following weeks, the case became a cause célèbre in the local media. The Arizona Republic ran a front-page story with the headline, HOA Shuts Off Hospital Water in Dispute. The story went viral, shared thousands of times on social media. Suddenly, everyone had an opinion about HOAs and their powers. The Sunset Ridge HOA became a punching bag in the court of public opinion. Residents of the development started speaking out, many expressing horror at what their board had done. Several homeowners filed a petition to recall the entire board. The legal case moved forward. Patricia filed an amended counterclaim, adding claims for intentional interference with business operations, gross negligence, and reckless endangerment. The damages sought climbed to over $500,000. True to his word, Judge Harrison had referred the matter to the Arizona Attorney General's office. 2 weeks after the preliminary injunction hearing, I got a call from an investigator named Robert Chen. Mr. Dawson, I'm calling about the water shutoff incident. We're conducting an investigation into potential violations of Arizona Revised Statute 36-424, which prohibits interference with medical facility operations. I'd like to come by and get a formal statement from you and review your documentation. I spent 2 hours with Investigator Chen, walking him through everything that had happened. He was thorough and professional, taking detailed notes and copying every relevant document we had. I have to ask, I said as he was packing up, is this really serious enough for criminal charges? Chen closed his briefcase and looked at me seriously. Mr. Dawson, Arizona law takes interference with medical facilities very seriously. Your hospital could have been forced to shut down completely. Patients could have died. Yes, this is serious enough. Whether charges are actually filed will depend on a lot of factors, but the Attorney General is taking this very seriously. A month after the preliminary injunction hearing, the HOA's lawsuit challenging the easement was dismissed. Judge Harrison issued a scathing written order finding that the easement was clearly valid and that the HOA's challenge was frivolous. He ordered the HOA to pay the hospital's attorney fees for having to defend against the meritless claim. The hospital's counterclaim proceeded to discovery. Patricia deposed all 5 members of the HOA board. The depositions revealed a stunning level of arrogance and poor judgment. Deborah Chamberlain, in particular, came across as completely convinced that the HOA was entitled to control the water line regardless of the easement. When asked why she thought the board could shut off water to a hospital, she responded, "We're the property owners. We have rights too." Even when those rights conflict with a recorded easement, Patricia had asked, the easement was old. We thought it should be renegotiated. So you decided to use shutting off the water as leverage. We needed to get their attention. By putting patients at risk? We didn't think it would actually hurt anyone. We thought they'd just agree to negotiate. The depositions also revealed that the HOA had never actually attempted to contact the hospital before the water shut off, despite Deborah's testimony. The supposed emails and letters simply didn't exist. When confronted with this fact, Deborah had claimed she misremembered the timeline. Patricia was building an overwhelming case. The hospital had documentation of every cost incurred due to the water shutoff. We had testimony from patients whose procedures had been postponed. We had expert opinions on the increased health risks created by the facility disruption. 3 months after the initial incident, settlement discussions began. The HOA's insurance company, which was now defending the case, wanted out. Their lawyers approached Patricia about resolving the matter. The initial offer was insulting, $50,000 and a mutual release of all claims. Patricia laughed and countered with our full damages demand of $520,000, plus an acknowledgement from the HOA that the easement was valid and enforceable, plus a permanent injunction against any future interference. The negotiations dragged on for weeks. The HOA's position was undermined further when 3 of the 5 board members resigned under pressure from the homeowners. Deborah Chamberlain stubbornly held on, along with Craig Stevens, but they were increasingly isolated. Then came the news that changed everything. Investigator Chen called me on a Tuesday afternoon in late August. "Mr. Dawson, I wanted to give you a heads up before this becomes public. The Attorney General's office has decided to file charges against the HOA board members involved in the water shutoff decision." My stomach tightened. Criminal charges? Yes. The grand jury returned indictments this morning for reckless endangerment and interference with a medical facility. It's a Class 6 felony. Deborah Chamberlain, Craig Stevens, and the 3 other board members who were present for the vote are all being charged. What does that mean for them? If convicted, they could face up to 2 years in prison, though first-time offenders more commonly get probation. But it's a felony conviction, which carries significant collateral consequences. The Attorney General wanted to send a message that you can't endanger patients for financial gain. The news hit like a bombshell. That evening, I watched the local news coverage showing Deborah Chamberlain being arrested at her home. The footage of her being led out in handcuffs, still protesting that she had done nothing wrong, was jarring. The criminal charges gave the hospital enormous leverage in the civil case. Within a week, the HOA's insurance company came back with a revised settlement offer. $400,000, full acknowledgement of the easement, permanent injunction, and a requirement that the HOA provide written notice and obtain court approval before taking any action that could affect the hospital's water access. Dr. Richardson called a meeting to discuss the offer. Patricia laid out the pros and cons. "We could probably win more if we go to trial," Patricia said, "but trial is expensive and time-consuming. This offer gets us almost everything we asked for. Plus, it resolves the matter now rather than a year from now." Marcus looked at me. "Daniel, you're the one who lived through this. What do you think?" I considered it carefully. "I think we've made our point. The criminal case will proceed regardless of whether we settle the civil case. The HOA is paying a significant price, both financially and reputationally. What's most important to me is making sure this never happens again." Dr. Richardson nodded. "I agree. Patricia, accept the settlement offer. Make sure the permanent injunction is ironclad. I want it to be impossible for any future HOA board to pull something like this." The settlement was finalized 2 weeks later. The hospital received $400,000, which more than covered our losses and legal fees. More importantly, the settlement agreement included language that made the easement explicitly superior to any HOA rules or regulations, and required the HOA to maintain the property around the water line in good condition. The criminal case took longer to resolve. Deborah Chamberlain, true to form, refused to accept a plea deal and insisted on going to trial. Craig Stevens and the other 3 board members pleaded guilty to reduced misdemeanor charges and received probation. Deborah's trial was scheduled for January. I was called as a witness and once again found myself on the stand describing the events of that chaotic first day. This time, the stakes were higher. This wasn't about money anymore. It was about accountability. The prosecutor, an intense woman named Angela Foster, walked me through the timeline. "Mr. Dawson, in your professional opinion, what could have happened if the water had not been restored that day?" We would have been forced to evacuate the entire hospital. Every patient would have needed to be transferred to other facilities. In a situation like that, with dozens of patients being moved simultaneously, the risk of adverse outcomes increases dramatically. People could have died. And Mrs. Chamberlain was aware she was shutting off water to a hospital? Absolutely. I told her directly when I called her that morning. What was her response? She said it was intentional, and that we needed to come to their board meeting with a checkbook if we wanted the water turned back on. The defense attorney, a different lawyer than had represented the HOA in the civil case, tried to argue that Deborah had relied on bad legal advice and genuinely believed the HOA had the right to control the water line. But the prosecutor shredded that argument by pointing out that even if they thought they had the right to renegotiate, shutting off water to a hospital without warning was grossly reckless. The jury deliberated for less than 3 hours. They found Deborah Chamberlain guilty of reckless endangerment, a Class 6 felony. At sentencing, Judge Maria Lopez, who had presided over the criminal trial, was direct. Mrs. Chamberlain, you put your desire for money above the safety and welfare of hospital patients. You showed a stunning lack of judgment and a callous disregard for human life. While I'm not going to send you to prison as a first-time offender, I want you to understand the seriousness of what you did. She sentenced Deborah to 3 years of supervised probation, 400 hours of community service, and ordered her to pay restitution to the hospital for costs not covered by the civil settlement. Deborah stood stone-faced through the sentencing, but I saw her hands shaking as she gripped the defense table. The case finally closed in March, nearly a year after that first chaotic day. The Sunset Ridge HOA had entirely new leadership, and they went out of their way to maintain a positive relationship with the hospital. They sent a formal letter of apology and established a communication protocol to ensure any future concerns would be addressed through proper channels. I was sitting in my office one afternoon when Sarah knocked on my door. "Daniel, there's someone here to see you." I looked up to find Natalie Brooks, one of the patients whose cardiac catheterization had been postponed due to the water shutoff. She was in her early 70s, a retired teacher with kind eyes. "Mrs. Brooks, please come in. How are you doing?" She sat down across from my desk. "I'm doing well, thank you. The procedure went fine once it was rescheduled. I just wanted to come by and thank you personally for everything you did. I saw the news coverage, and I know you were the one who got that judge to order the water turned back on." "I was just doing my job, madam." "No, you did more than your job. You fought for us patients. I know that woman who shut off the water, Deborah Chamberlain. She lives 3 houses down from me. Always thought she was better than everyone else. I'm glad she finally got held accountable. I'm just glad you're okay and that we could get you the care you needed. That's why I came. I wanted you to know that it mattered. What you did mattered." After she left, I sat for a while thinking about the past year. It had been a baptism by fire in my new job, but it had also taught me something important about standing up for what was right, even when facing opposition from people who thought their authority made them untouchable. The hospital had weathered the crisis and come out stronger. We had updated our emergency protocols, established better relationships with our neighbors, and ensured that our legal rights were protected beyond any doubt. As for Deborah Chamberlain, I saw her occasionally around Scottsdale, always looking bitter and angry, as if the world had wronged her rather than the other way around. The other residents of Sunset Ridge largely avoided her, and I heard through the grapevine that she'd been trying to sell her house and move away from the neighborhood that now viewed her as a pariah. The case became something of a legend in healthcare facilities management circles. I was invited to speak at a conference about protecting hospital infrastructure and dealing with difficult neighbors. The story of the HOA that shut off a hospital's water and faced criminal charges became a cautionary tale used in law schools and HOA management training programs. On the anniversary of the incident, Dr. Richardson called me up to her office. "Daniel, I wanted to personally thank you for how you handled the situation last year. You kept your head, you documented everything properly, and you helped us achieve a complete victory. That's why I'm promoting you to Vice President of Facilities and Operations with a corresponding salary increase." I was stunned. "Dr. Richardson, I don't know what to say." "Say yes. You've earned it. Yes, Absolutely yes. That evening, I drove past the Sunset Ridge development on my way home. The entrance had a new sign that read, Sunset Ridge, a community that cares. I couldn't help but find that ironic given everything that had happened, but at least they were trying to rehabilitate their image. My phone buzzed with a text from Marcus. Congratulations on the promotion. Drinks tomorrow to celebrate? I smiled and texted back, definitely. As I pulled into my apartment complex, I reflected on the bizarre journey that had started with my first day on the job. I had never imagined that I would end up in court, facing off against an HOA president who thought she could extort a hospital. I had never imagined watching someone get arrested for shutting off our water, and I certainly had never imagined that it would all lead to a promotion and a new chapter in my career. But life has a way of throwing unexpected challenges at you, and the only thing you can do is face them head-on with integrity and determination. The HOA had learned that lesson the hard way. Deborah Chamberlain had learned that being on a board of directors didn't place you above the law, and I had learned that sometimes doing the right thing meant standing up to people who were used to getting their way. The water flowed freely to Mercy General Hospital, as it always should have. The easement was secured, the patients were safe, and justice had been served. In the end, that was all that mattered. 6 months later, I got one final piece of news about the case. Investigator Chen called to let me know that Deborah Chamberlain had violated the terms of her probation by failing to complete her community service hours and had been sentenced to 90 days in jail. Apparently, she had believed that her probation officer wouldn't actually enforce the requirements. She was wrong about that, just as she had been wrong about so many things. The judge who handled the probation violation was not sympathetic to her excuses and made it clear that felony probation was not optional. I thanked Chen for the update and hung up. There was no satisfaction in knowing that Deborah was going to jail. It was just sad that she had never learned the fundamental lesson that should have been obvious from the start. You can't put people's lives at risk for money, and you can't abuse whatever small amount of power you have without facing consequences. The hospital continued to thrive. We never had another issue with the water supply, and the new Sunset Ridge HOA board went out of their way to be good neighbors. They invited hospital staff to their community events, and we reciprocated by hosting health fairs and vaccination clinics for their residents. It was a reminder that most HOAs, like most organizations, are only as good or bad as the people running them. The problem wasn't really the HOA structure itself. It was what happened when small-minded people with inflated senses of their own importance got a little bit of authority and decided to wield it like a weapon. As I settled into my new role as vice president, I made sure that our facilities team maintained detailed documentation of all our easements, access rights, and infrastructure relationships. I never wanted to be caught off guard again. But more than that, I wanted to ensure that if we ever faced another challenge like the water shutoff, we would be ready to respond swiftly and decisively. The story had a happy ending for the hospital, and for me personally. We had protected our patients, vindicated our legal rights, and seen justice served. The fact that it had all started on my very first day on the job would always be a source of both stress and pride whenever I told the story. Sometimes I would be sitting in meetings, dealing with routine facilities issues like HVAC maintenance or parking lot repairs, and I would think back to that chaotic first day. The panic of discovering we had no water, the shock of learning it had been done deliberately, the rapid mobilization of legal resources, the tense court hearings, the ultimate victory. It was the kind of experience that either breaks you or makes you stronger. I like to think it had made me stronger, more confident in my ability to handle whatever crises might come my way. Because if I could navigate an HOA, shutting off our water and come out on top, I could handle just about anything. The other facilities directors I met at conferences always wanted to hear the story. It had become legendary in our field, a worst-case scenario that most people couldn't imagine actually happening. But it had happened, and we had dealt with it, and the hospital was better for it. Looking back now, almost 2 years later, the whole thing seemed almost surreal. Had an HOA really shut off water to a hospital? Had their president really thought that was an acceptable negotiating tactic? Had they really been so blind to the obvious legal and moral problems with their actions? The answer to all those questions was yes. They had done it, they had thought it was fine, and they had paid the price. Deborah Chamberlain had a felony conviction on her record. The HOA had paid hundreds of thousands of dollars in damages and legal fees. Their reputation in the community had been destroyed, and Mercy General Hospital continued to serve the people of Scottsdale, with clean water flowing freely through pipes protected by an ironclad easement and a permanent court injunction. The patients received the care they needed. The surgeries proceeded on schedule. The emergency department remained open and ready to help anyone who needed it. That, in the end, was what mattered most. Not the legal victories or the criminal convictions or the settlement money. What mattered was that the hospital could do its job, that patients could receive care, that lives could be saved. Everything else was just ensuring that nothing interfered with that fundamental mission. I sometimes wondered if Deborah Chamberlain ever understood that, if she ever grasped that her actions hadn't just been illegal or unethical, but had threatened the health and safety of real people who needed medical care. If she ever felt genuine remorse rather than just anger at being caught and punished. I doubted it. People like that rarely changed. They went through life believing they were always in the right, that anyone who opposed them was the enemy, that rules and laws and basic human decency didn't apply when they conflicted with what they wanted. The world was full of petty tyrants who used whatever tiny amount of authority they could claim to make other people's lives difficult. But the world was also full of systems and institutions designed to check that kind of abuse. Courts that would issue emergency orders to protect hospitals, prosecutors who would file criminal charges against people who endangered patients, juries who would convict those who put their own interests above public safety. The system had worked. It hadn't worked as fast as we would have liked on that first day, sitting in the hospital with no water and patients at risk. But it had worked. Within hours, a judge had ordered the water restored. Within months, the hospital had been compensated for its losses. Within a year, the responsible parties had been held criminally accountable. Justice had been served, and an important precedent had been set. No HOA in Arizona, and probably in the entire country, would ever again think they could shut off water to a hospital without facing serious consequences. The case had sent a clear message about the limits of HOA authority and the inviolability of medical facility operations. As I sat in my office at Mercy General Hospital, surrounded by the mundane paperwork of facilities management, I couldn't help but feel grateful for how everything had turned out. It had been a harrowing experience, but we had emerged victorious. The hospital was secure, the patients were protected, and I had a story that would last a lifetime. And somewhere out there, Deborah Chamberlain was serving her jail time, hopefully learning the lesson that she should have understood from the beginning. You don't mess with a hospital, and you don't put patients at risk. Not for money, not for power, not for any reason. The water flowed, the hospital thrived, and life went on. That was the real ending to the story, not dramatic or exciting, just the simple continuation of important work by dedicated people. And really, that was exactly how it should be.